served, in accordance with the rules, we've served subpoenas for this hearing today, and one of those that we served was to the Internal Affairs Investigator for the appointing authority. She is the investigator which was responsible for creating an investigative report. Part of this case, and I think that we're going to argue throughout the case, is that they avoided, intentionally, if you will, disregarded that very investigative process. She's a critical witness because she is the one who is supposed to do the investigation for which you all are here today for, which will be evidence to use to terminate Captain Gardner. Very critical witness in our case. We had her served. She is the employee of the appointing authority. She is the only internal affairs investigator employed by the appointing authority that was involved in this case. So she is the linchpin, a very important witness for our client in this case. We had her served, and what I have here is an affidavit of service. So we understand she's been served and she is the employee of the appointing authority. And we think without her, I don't know why she's not here today, being an employee of the appointing authority, you would think that they would certainly understand that she's necessary. But we need her in order to give a fair and a partial and an opportunity for you, the board, to make a decision and hear the evidence that she's going to present.
Feel a motion coming or something.
I'm sorry, but I wanted to do it up front, and I apologize to everyone. You know, this is the only way we can have witnesses appear here. You know how important it is for us to have witnesses for our client. They have a right to, if you will, confrontation, which means confronting your witnesses. This being the internal affairs investigator whose report or lack thereof is going to be used to terminate Captain Gardner. I think it's necessary and required that we ask for continuance or postponement. We can have her here, and we think that that's something that's appropriate. So,
have you had some indication she's not coming? She's not here yet.
Well, I've been told, and again, I don't want to say by other witnesses that are here, that she will not be coming.
What's the point of continuing if she's not going to come anyway?
Well, if that is, you understand, if we have a right to a subpoena, and she is an employee of the appointing authority, she is their employee, she's not going to appear, that is detrimental to our ability to confront the witness. And that's a critical point for us to be able to bring out in this case. What was done to investigate and what wasn't done to investigate. Without her here, you all won't have that opportunity, and it severely limits us to be able to present that evidence. So I don't know that she won't come, but certainly being an employee of the appointing authority, you would think that there would be some ability to have her here.
She's definitely not here now.
She is not here this moment.
If I could be heard on this issue. Captain Dofflemyer did the initial internal affairs investigation. As you all know from doing this job as board members for a long time, the internal investigation, in whether it's the sheriff's office or any other department of public protection, leads to or requires the investigator to do interviews of witnesses and to ultimately present the internal investigation to the appointing authority for a decision. The internal affairs investigator, as you may recall, rarely testifies when the live witnesses who were interviewed for the investigation are available to testify. And I've mentioned to Mr. McKinnon that I believe all of the witnesses that were interviewed in this, both the initial internal affairs investigation, which was conducted by Captain Dofflemyer, as well as the reopened investigation that was conducted by Mr. Smith from the county attorney's office, all of those witnesses, I believe, are here or expected to be here sometime during these 2 days. It's our position that Nikki Dofflemyer has no direct evidence, no relevant evidence to the termination of Mr. Gardner. If you look at your procedural rules, and as you know, I provided you with a document earlier this week regarding that. This is a little bit of an unusual case, and I'm not trying to get off the subject of Captain Dofflemyer, but in this case, you were provided copies of the notice of intent to terminate as well as the final letter. It's our position that the notice of intent letter is really not relevant to your determination of the final decision because your rules provide that you will be bound by and I'm quoting from the rule that I had in the memo to you, the hearing must be confined to the charges contained in the statement of adverse action given to the employee at the time the action was taken. So in this case, the letter that was given to Captain Gardner that terminated his employment was the final letter authored by Acting Director Mr. Rechtenwald. And again, Captain Dofflemyer's testimony she wouldn't have any firsthand testimony regarding what any of these witnesses that testified in this case have to say. The witnesses are available, so any questions that they may have about Captain Gardner's actions can be asked of those witnesses. So we don't believe that whether she's going to be here or not. As you know, these subpoenas are non-binding. I have no idea what I know Captain Dofflemyer is scheduled to retire. I don't know when, so she may already be retired. So we don't have any way to force someone to be here.
Yeah, I mean, if I may just respond just briefly. Captain Dofflemyer is a key witness with personal knowledge. This is a termination of a police officer. And police officers has very specific policy, investigative process, due process. They also have a statutory right under the Policeman's Bill of Rights. Captain Dofflemyer was very, in her own capacity, has personal knowledge about how the process was done. Our case, as you will hear throughout the case, is that the decision was made long before Mr. Rickenwald was appointed just recently in this case. The decision was made way back in October of last year. And the decision was set in stone. And you will see through the testimony of Captain Dofflemyer that the investigative process that she began was terminated. The investigative process was terminated. And that there is only one investigative report, only one in this entire case, and it's the one she authored. That's it. There is no other investigative process. That process was abandoned, and it's through her testimony that we'll be able to show this board how those violations of that policy, those Policeman's Bill of Rights and the merit rules were violations, and that's how we got here. So she is a very critical witness for us. Again, talking about an employee of the appointing authority, the internal affairs investigator in this case. And so we believe that's critical for us to be able to prove that. That's correct, sir.
I think it's probably a good time, since Mr. McKinnon brought up the police officer bill of rights, law enforcement officer bill of rights, as I suspected that issue would come up today, and I think it's probably a good time for me to address that. The law enforcement officer bill of rights are rights that are statutory, and they're provided for a law enforcement officer who is under investigation for actions that may result in adverse action to them. It is something that provides for a due process during that investigative procedure. Mr. McKinnon has actually already raised this in circuit court with Judge Rouse and the Bill of Rights allegations of Bill of Rights violations, and actually his decision is currently on appeal to the 5th District Court of Appeals. It's the county's position that, based again on your procedures and the merit rules that give you authority, that whether or not Mr. Gardner's rights were violated during the investigative process is not an issue for your consideration today. It's not, the statute doesn't provide that you have any remedy to give him, and it's something that is handled through the courts and is actually in the courts. So it's our position that the Bill of Rights issue is not relevant to you and not admissible, which, if that's the primary motivation for Captain Dofflemyer's testimony, we would object to that anyway. In addition, there's been an allegation that the internal investigation stopped and did not continue, and I want to get this on the record as well for any future purposes. As you know, our procedures, for the most part, having been on this board, there was an internal investigation initiated. There was a notice of intent to terminate. Pursuant to our merit rules, Mr. Gardner was allowed to rebut or respond to those to the intent letter, and he did that through Mr. Caney. Mr. Caney raised a number of issues in his response that the county appointing authority at the time decided to do, that he needed to look into those. In other words, there was something provided by Mr. Caney that made the appointing authority say, well, maybe I need to look into this before I take the final action. And so that investigation was reopened at that time. That is allowed for in the Police Officer's Bill of Rights, even though that's not relevant to your determination. It was reopened. There was an additional investigation, or not additional, but additional testimony taken to clarify the issues raised by Mr. Caney, by Mr. Gardner's attorney, and that was done by Mr. Larry Smith. It's our position it was one continuing investigation. There wasn't a stop and a start. Either way, it wouldn't matter for your purposes, because he was not given the final letter of termination until after the conclusion of the complete internal investigation. And we believe the evidence that was established during the reopened investigation was just additional evidence towards the original charges. So there wasn't any